Hi, my name is Spencer Couch. I'm one of the wealth strategists here at Paradigm Life. Welcome to Cover Your Assets, How Proper Estate Planning Will Protect Your Assets for You and Your Heirs. I hope you enjoy this presentation. First, let me introduce myself to you a little bit more. As I mentioned, my name is Spencer Couch. I've been a wealth strategist with Paradigm Life for the last 3 years. This is a picture of me and my family. I'm married with 3 kids, a 9-year-old, a 5-year-old, and an 8-month-old. Prior to coming to Paradigm, I practiced law for a number of years. I practiced mainly in 4 areas: estate planning, asset protection, tax issue resolution, and consumer bankruptcy. Now, regardless of where my clients came from, what their socioeconomic background was, how much money they had, how little money they had, what their credit situation was, they all wanted the same 2 things. Number 1, to protect their assets during their lives so they could retain them and use them in the ways that they saw fit and most beneficial to them. The second thing was to leave as large a legacy as they possibly could. Now, these 2 things were kind of the inspiration for my entire practice, trying to solve these problems, trying to help people. So, I went to law school. I passed the bar. I practiced law for a number of years. I went into a lot of debt to get this degree. Why on earth would I leave that to come to Paradigm Life? Well, as I was searching out answers to those 2 questions that all clients had, how do I retain my assets for myself? And how do I leave as large a legacy as possible? I stumbled upon Paradigm Life. I actually knew one of the agents here. I'd known him for over a decade, and he started telling me about this new thing that he was doing, this new job that he had, and how he was teaching people to use their assets in different ways. I had come from a very skeptical background. That's what you get when you go to law school. When you sit through the Socratic method with professors for 3 years, you're going to get a little bit skeptical. And I was skeptical. So as this agent here was telling me about all of these benefits that this program supposedly had, I was a bit skeptical. I knew life insurance to some extent. I knew that it was a great way to pass on a legacy, and that I knew that in my bankruptcy practice it gives you a lot of protection in a bankruptcy as well. But I didn't know how beneficial it truly could be. So as I researched things, I found that not only was this a system that I wanted to implement for myself and my family, to give me the answers to those 2 questions in my life, to protect my assets during my life, and to leave as large a legacy as I possibly could. But this was something that I felt would be very beneficial for the vast majority, if not all, of my clients. As a result, I ended up shutting down my law practice, and I have been doing this as a wealth strategist full-time for about 3 years now. I don't regret it for a minute. Now's the time for me to do the very attorney-like thing, and that is to provide a legal disclaimer. The materials and information provided during this presentation and as a result of this presentation are for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this presentation or any communications regarding the presentation topics do not create an attorney-client relationship between myself, Paradigm Life, and the viewer of the presentation. The opinions expressed during or deriving from this presentation are the opinions of the individual author, myself, and may not reflect the opinions of Paradigm Life or any individual attorney. Again, if you have legal questions or needs, please contact your attorney. So today we're going to talk about the purposes of estate planning. And there are 2 main purposes. The first is to protect your assets at death. When you die, we want to make sure that the state and creditors get as little as they possibly can, because that will mean that as much as possible goes to your family. This is the traditional idea and traditional understanding of what estate planning does. The second thing estate planning will do, or at least proper estate planning, will give you protection during your life. Protect your assets during your life so that they're not subject to a lawsuit, or as little as possible could be, depending on what your overall situation is. So these are the two things that we're going to really discuss here today. Now, I know most of you didn't go to law school. I know that attorneys are not necessarily the highest valued or highest looked upon profession. Please forgive me for that. I'm a recovering attorney. I'll try to make this as interesting as possible, and hopefully you'll get some great information out of this. Now, the number one question I was asked when I was dealing with a client who didn't have a large estate is, if my estate is not large, why on earth would I need to pay for expensive estate planning tools? I don't have a lot. And when it comes to estate planning tools, there are many of them: wills, trust, durable power of attorney, living will, healthcare proxies, ILITs, CRTs, limited partnerships, and so on. There are many other asset protection and estate planning tools out there. They can all be expensive depending on your situation, depending on your state. Now, what I mean by expensive is there's an out-of-pocket cost for that, and you're paying an attorney. Attorneys like to charge as much as they can. So there's a lot of expense there. Why would you need to do that if you have a small estate? Even here in Utah, where legal fees are relatively minor compared to some other states, a simple estate plan can easily cost you $3,000 or more. So again, we come back to that same question. If your estate is small, do you really need an estate plan? Well, there's a quote that I've seen that I don't know who to attribute it to, but it's one that I really liked when it comes to estate planning. And it says, "For those who die without a will, an intestate statute provides an estate plan designed by the state legislature." Now, I don't know about you, but I don't want the state legislature planning my estate. And basically what that means is if you don't have any sort of estate plan in place, the state gets to control how your estate is distributed. Regardless of the size, there's going to be a significant impact on what passes on to your heirs. So let's talk a little bit about that next step, what that is called, what it is, and how it works. When we die, our estate goes into what's called probate. Now, there are two different types of probate. There's testacy probate and intestacy probate. These are really simple definitions. Number one, testacy. This is when a person dies with a will in place. They have a last will and testament. They have declared what they want done with at least a portion of their assets. Intestacy is simply the opposite, when someone dies without a will. Now, the simple act of having a will in place will have a gigantic impact on your estate. Now, obviously, the bigger your estate is, the bigger that impact will be, but there will be a significant impact either way. So first, testacy has certain benefits. Intestacy has certain problems that we would like to explore and compare. First is testacy. The testator, the person who died, the person who created the will, gets to control how their property is distributed, at least to some extent. They can distribute personal property. They can leave certain things to other people. They can leave certain people out of a will if they want to. They get to have some level of control over what's going to happen with their estate. Now, on the intestacy side, we give up that control. The state legislature has created that intestacy statute, and that has a formula based on however you fit into it. It will determine how your property is distributed. Now, typically speaking, intestacy is going to distribute in a similar way, if not exactly the way that most people would like their estate distributed. However, personal property doesn't get to be taken into account here. Okay, so when we die testate or with a will, we get to simplify the probate process. It's gonna go a little bit more simple. It's gonna go a little bit smoother. So when we die intestate, there's no way for us to determine what happens with our property. There are no exceptions to how that is going to be distributed. It's a formula that is going to be applied regardless of what our desires would be. And this, again, is why we would not want the state to have control over what's happening with our estate. Now, when we die testate, we've made our desires known to the court. So the court does not need to decide how to distribute the property, and a lot of that goes into the problem of an intestate probate. And that is, the court needs to decide how much property is worth. The court may have to liquidate property depending on who may or may not be willing to buy a certain personal property from the estate. There's a lot that goes into it to determine what the assets are worth and how to distribute it. Now, if you simply distribute it based on your will, so regardless of what the value of any personal property is, you get to determine what property goes to whom. And as a result, you get a lot more control. There also, one of the benefits of testacy probate is high attorney fees. Attorneys make a lot of money if you're testate. Not only did they make money when they created your will, but the attorneys who are representing your estate in probate are going to make significant fees. That sounds like a bad benefit, but it is a good benefit because in testacy, attorneys make a lot more. There's a lot more to fight over, a lot more to determine. Their hourly rates time increases, and as a result, they can make a whole lot more money. So in the end, who benefits from probate? Whether you're testacy or intestacy, the only people who truly benefit from it are the attorneys. Now, this isn't to say that there's no difference between testacy and intestacy. Obviously, there are differences. We just listed a bunch of them. Going into probate, testate, or with a will significantly reduce the attorney's fees and costs and will allow as much of your assets as possible to pass on as a legacy to your heirs. Let's talk about the basics of estate planning. There are a number of instruments that you're going to be familiar with as to how to plan an estate. The first and foremost is a will. Last will and testament. This is a written document where you get to say who gets what. You can distribute your property however you want, and there are limited abilities of heirs to contest a will. Basically, you get to choose how your property is distributed. Now, who should have a will? Does everyone need a will? Absolutely. Every individual person should have a will. That means husband and wife should each have a will. That means that once a person reaches the age of majority, or 18 years of age, or within a reasonable period of time afterwards, they should get a will set up. The wills can be adjusted over time. You're not going to have the exact same estate and the exact same needs throughout your entire life. A will is also where you get to influence the court in determining who will be the guardian of your underage children should you pass away before they reach 18 years of age. So a will is a very important thing. Everyone should have one. Now, another very common estate planning tool is a trust. A living trust or a family trust, or they go by any number of names, and there are any number of different types of trusts, and we'll talk about a couple of them here today. But this is simply a contract, and you as the trustor or settlor get to fund this trust and put your assets into it, and the trust will control those assets. Now, you get to control the trust, but it's a great way of adding a level of protection. Now, who should have a trust? Well, not quite like wills, but most families should have a trust. I have a trust for my family. I recommend for most family, especially if you have children, then a trust is a worthwhile tool to have in your toolbox. Now, there are many differences between wills and trusts. Let's talk about a couple of them. Number one, when they go into effect. A will is not effective until the death of the person whose will it is. It is their last will and testament. It can't be last until they've passed away. That means you can change, you can add to, you can get rid of a will at any time prior to death. A trust goes into effect when you sign the trust, when you create that contract. It is something that can go into effect ahead of time and can control your assets and own your assets prior to death. Another difference is a will is an individual thing. Every individual should have a will. It is their individual last will and testament. You can't have two people as in the same will. In a trust, there can be more than one trustor, a husband and wife. My wife and I are joint trustors of our trust. We are also the joint trustees. That's simply stating that we get to control it during our lives. But we are jointly partners in that contract. Another thing with trusts is trusts can avoid probate. Instead of going into probate testate like a will would, a trust can simply circumvent probate. You can minimize the amount of your assets that have to go through probate and therefore minimize the cost of probate by having a trust set up. This is a great tool for you to implement in order to avoid as much cost and expense as possible when you die. Now, who should have a will or trust? We've already talked about this to some extent, but everyone should have at least a will, and ideally you would have both. Most families should have both. So let's talk about some of the other basic estate planning tools. You may be familiar with a lot of these. We won't spend a whole lot of time on them. Number one, a durable power of attorney. This allows someone that you designate to access and control your financial assets if you become unable to do so. If you are disabled or become of feeble mind or unable to control your assets, someone else can control them for you and work in your stead should that be needed. A living will. This indicates what you want done if you are incapacitated and may or may not need life-sustaining medical treatment. This is basically saying, I don't want to be a vegetable. I want you to pull the plug, or something like that, to take it to an extreme there. That way, you get to free your spouse or kids of the responsibility of deciding what you would want done. A living will make that determination ahead of time. Next is a healthcare proxy. This identifies the person you want to make medical decisions on your behalf if you became unable to do so. So maybe not in a life-threatening situation where you determined, okay, I don't want to be artificially kept alive, but in a situation where there may be other determinations that need to be made. A healthcare proxy would be the person, similar to a durable power of attorney, that would be able to make those decisions on your behalf. Everyone should have a funeral plan. You don't have to leave this up to your heirs, your kids, your spouse to determine what you would want done in your funeral. I recently had the opportunity to go to a funeral of my brother-in-law's father, who passed away in a relatively short period of time. He was able, though, to create a funeral plan and determine who he wanted speaking at his funeral, how he wanted it to take place, what should happen at the funeral. And as a result, it was a great funeral. And his family did not have to make any determinations regarding that. One thing that can be very beneficial, and that will come into play a little bit more here down the road in this presentation, is an irrevocable trust. A little bit different than a living trust. A living trust is something that it's simply a contract that you create and you allow for your property to go into and be controlled by. An irrevocable trust is something that is, as it says, irrevocable. You can't change it, you can't dissolve the trust without the permission of the beneficiaries of that trust. Whenever you create a trust, you're going to name beneficiaries, typically your heirs or whoever the trust is going to benefit. In an irrevocable trust, you are limited on what you can do with the assets in that trust and what you can liquidate from it. Now, there are certain benefits to an irrevocable trust that you don't get in a regular trust, an added layer of protection for you, even more so than with a trust. Now, of course, we being Paradigm Life, another basic estate planning tool that everyone should have is life insurance. It's there to protect your family and your estate should you pass away prematurely. So let's take a case study. Now, this is a case study that I've made up out of whole cloth. It's simply something that I've created out of my mind to illustrate a worst case scenario or an extreme scenario as to how estate planning tools can work. The effects that we see in this will not necessarily apply directly to you. This will just give you an idea of how estate planning can protect your assets at death, and then we'll look at how they can protect your assets during your life as well. Now let's take a look at a few assumptions here. Number one, this is a couple that has done no estate planning. They have done well in their lives, they've saved well, they've accumulated a lot, but they have not done any estate planning. Now this couple is on a road trip and they die in a car accident. They have a $15 million estate that consists of a $500,000 home, $500,000 in other personal property, $5 million in an employer-only IRA. He was self-employed, and he had a little IRA that only benefited him and was limited to him, but sponsored by the company. They have $5 million in a Roth IRA that they've accumulated over a number of years. They have $4 million in savings, money market accounts, stocks, bonds, and mutual funds that they like to play around with a little bit here and there, and they use for their regular savings and things like that. Now, this couple has 3 kids, ages 35, 38, and 41. Now, they die in a car accident. All the kids have taxable income of $100,000. They die in a car accident. The law is going to play a role here. What is the law going to do with that accumulated estate that they have built up? Okay, let's talk about what happens to their assets at their death. First, the entire $15 million of the estate goes into intestacy probate. What that means is they're going to be estate taxes. First, the gross estate is $15 million, and in 2017, there is a federal estate tax exemption of $5,490,000 per person, meaning as a married couple, they can exempt from taxation $10,980,000. This leaves a taxable estate of $4,020,000. Now that at a 40% estate tax rate is going to give us $1,608,000 of estate taxes that will be paid to the federal government. Now there are some states that have state estate taxes as well. Most states do not, but that is something you'll need to look into in your state. So what this means is net of estate taxes, $13,392,000 is going to pass to the heirs. $10,980,000 of that is going to be exempt as gift taxes, exempt from estate taxes, and that also makes it exempt from income tax because it is considered a gift, exempting it from that. As a result, the portion that is taxable as income to the heirs is $2,412,000, or $804,000 each. Remember, they had 3 kids. So let's talk about the income taxes of the heirs. Income tax is a big burden. Each of them receive $804,000 that is going to be taxable. Remember, they each had $100,000 of income, and as a result, this $804,000 of one lump sum receipt is going to significantly impact them. Now, again, this is a simple worst case scenario type situation. Obviously, there are some things that we can do to minimize those taxes, roll them into certain types of IRAs and certain types of other vehicles, things like that will minimize the taxes. This is a worst case scenario. If they took all of it at once, they would be looking at this. Marginal tax rate bumps them up into the highest rate that we currently have, 39.6. I assumed 5% taxes for states. That's what it is here in Utah. Every state is a little bit different, though. The tax breakdown. They have earned income of $100,000 each. As a result, on that, they're going to pay $15,292 of federal taxes and $5,000 of state taxes. However, their inherited income is going to boost them up into higher tax brackets. The way that marginal tax brackets work is certain amounts of income will be taxed at certain rates until you reach the next higher marginal tax bracket. Eventually, you get to the highest of 39.6, and that will every dollar you earn after that will be taxed at 39.6%. What this does is it will increase their federal bill by another $270,000, $274.58, and it will add $40,200 of state taxes as well. So altogether, they pay $330,950 in taxes for the year that they inherit this money. So let's take a look at the same couple, the same estate size, except for they did a little bit of simple estate planning. So they die in a car accident, $15 million estate, $500,000 home, $500,000 of other personal property, $2 million in an employer-only IRA, $5 million in a Roth IRA, $2 million in savings, money market, stocks, bonds, mutual funds, but $5 million of their assets are in a whole life insurance policy. They have a $5 million death benefit that is owned by an irrevocable life insurance trust, or an ILIT. Remember I mentioned earlier that an irrevocable trust is going to come into play a little bit later on. This is where that's going to have a huge impact on what happens here. Now, to set up an ILIT, it's fairly simple. It's going to cost you very little money, relatively speaking, and it gives you an extreme amount of protection for those assets. The downside is you restrict your ability to use that asset. It's a great tool for asset protection. Not so great a tool for use in the way that many of our clients do, in an infinite banking or perpetual wealth growth type strategy. Now, the three kids, again, 35, 38, and 41, they all still have taxable income of $100,000. But to add a little bit more to it, the parents created wills to distribute their personal property. This will take the decision as to how to distribute that property out of the hands of the government and allow them to control that. So each kid may not receive an exact equal share, but generally speaking, parents will try to keep it as equal as they possibly can. So what happens to their assets at death in this situation? First, there's only a $10 million estate that goes into testacy probate. $5 million that is in the ILIT is not part of the estate for tax purposes. It is a contract that pays out a death benefit, a tax-free death benefit at their death, but it is not considered part of the estate. What this means is their gross amount that will pass, that will go to kids, is going to be the same $15 million. But for estate tax purposes, their estate is only worth $10 million. Now remember, the 2017 estate tax exemption is $10,980,000 for the pair, $5,490,000 each, which means that they have a taxable estate of zero. This also means that there will be zero estate taxes, meaning that the net that is passed to the kids is $15 million. Now, the entirety of this inheritance is going to be income and estate tax free. They will pass either through the gift tax exemption or death benefit, which is going to be income tax free. And because the death benefit was owned by an ILIT and not part of the estate, we don't run into any kind of estate tax problems. So let's look at the legacy here. Without estate planning versus with estate planning. Without estate planning, the estate taxes are $1.6 million. The inheritance tax, estate taxes with the planning is zero. The inheritance without the estate planning is $13,392,000. The inheritance with a little bit of estate planning is $15 million, $1.6 million more. Per heir without estate planning will give them $4,464,000. With estate planning, $5 million each. Income tax on the inheritance, $931,974 without estate planning, with it's zero. Income tax per heir is $310,658, and it's zero with the estate planning. So the total assets passed without any estate planning is $12,460,026. With the estate planning, two very simple things: a will and an ILET, $15 million, $2.5 million more than without doing a couple $1,000s worth of estate planning. So this is an example of how estate planning can benefit you at your death. A little bit of estate planning goes a long way when it comes to your legacy and the inheritance that your heirs will receive. So let's talk a little bit about protecting your assets during your life. Now, money in a 401k, IRA, and other government-sponsored plans are protected in the event of a lawsuit, right? Well, not necessarily. It depends on your state. Each state is going to vary a little bit. There's significant protection there in most states, but there are limitations to that in the event of a lawsuit or in a bankruptcy. For example, let's take California. IRAs do receive some protection there, and they receive protection to the extent that funds are necessary for support of the judgment debtor. Now, in a bankruptcy situation in California, so should you have so many debts or whatever that you have to pay or that you have to file a bankruptcy, your limitation to exempt that IRA is $1,283,025. Roth IRAs don't receive any protection though. So your money may or may not be fully protected. So let's talk about some of the types of accounts that are at issue here. Typically, an ERISA account, and ERISA stands for Employee Retirement Income Security Act of 1974. So it's an act that was enacted back in 1974 to protect certain types of accounts. So typically, these ERISA accounts will be exempt from lawsuits. But non-ERISA accounts, things that don't qualify under that act, may be at issue, and depending on your state, they may have some protection, they may have none. Some of these types of accounts are here. So traditional IRAs, Roth IRAs, SEP plans, simple IRAs, Keogh plans, 403Bs, plans that do not benefit employees. So earlier I mentioned employer-only IRA, things like that, government plans and church plans. They don't necessarily give you any level of protection depending on your state. What if this couple got in that car accident? They survived, but they had seriously injured or killed another driver, and they're sued, and they're found to be at fault. What's going to happen then? So if they have no estate planning versus a simple estate plan, a worst case scenario, and we're going to take California because we quoted that IRA number earlier, and many of our clients do live in California. So as a result, let's look at that. So under asset protection in California, you get to protect $175,000 of a homestead as a married couple. Your personal property, you get to exempt $18,150, and there are some additions to that. Clothing and furnishings and things like that, and food are also going to be exempt. So there's going to be a bit more on top of that. But other personal property, $18,150. Retirement accounts, they get to exempt $1,283,000, and so they are limited to a total exemption in a bankruptcy type situation of $1,476,175. From their $15 million estate, they are now left with $1.4 million, less than 1/10 of what they started with. Now let's take a look at a simple estate plan in California. That same situation. They've done an ILET and they've got a will. So asset protection, they get same homestead exemption. They get same personal property exemptions, retirement account exemptions. So their total is still the $1.4 million. Now they also have the ILET. So their estate, the amount of legacy that they're still going to have is going to be $5 million. Now in a situation like this, an ILET An irrevocable trust, remember, you can't change anything with that trust without consent of the beneficiaries. In a situation like this, it is entirely feasible and entirely possible that the kids as beneficiaries of that ILIT will grant their parents permission to access some of those funds and use those funds as necessary. However, this gives us a grand total of $6.4 million instead of $1.4 million. So significantly better for a relatively small fee of setting up an ILIT and creating a will. Now, let's say they added a slightly more comprehensive estate plan. Again, the simple estate plan gives them the same $6.4 million estate at the end of this lawsuit. Now, if they do a more comprehensive plan, again in California, now what I mean by more comprehensive is, let's take a look at it. Asset protection, homestead. If their home is owned by a trust, that trust is going to give them an added level of protection. Meaning that $500,000, the value of the home, could be exempt from any lawsuit. Personal property owned by the trust, cars and things along those lines, that is going to give them the same protection as the home, meaning the entire $500,000 could be exempt. So simply by having a trust and funding that trust by transferring and retitling their property into the name of the trust will add an additional layer of protection. Their retirement accounts, they still get to exempt the same amount. They still have the ILIT in this situation, which means their total estate now is $7.2 million instead of 6.4 or 1.4. We're still giving up half of the estate in this situation, a little bit more than that, but we are retaining significantly more. We get almost 50% of it, whereas before we were less than 10%. So a few simple estate planning techniques will help you out significantly. Now, in conclusion, should you have any estate planning done? If you haven't done anything, if you don't have any estate plan, should you do something? 100% absolutely. Even a little bit of estate planning is going to go a long way to protecting your assets during your life, as well as giving your heirs as much as possible. Now, again, I did go to law school. I did practice law. I am not practicing law currently. I am not giving any legal advice regarding an estate plan. You should speak with a licensed attorney in your state who is an expert in your state's estate planning laws. So if you need recommendations regarding that, we do have a couple of people that we can recommend for you who are experts in various states as well. So feel free to reach out and talk to your agent about that. Now, if you have any questions, I'm going to be manning my booth here in the summit here, at least until the top of the hour. If I have a lot of questions there, I'll be happy to continue along and stay there answering those questions. If I'm no longer there, you can typically leave a question for me there, and I can respond to you via email, or please reach out to your agent and ask them, and we can get you any answers that you need. Thank you for your time. I hope this was helpful for you.